Bill will be now read a second time, and I call the member for Moreton.
Thank you very much, Deputy Speaker. And I too rise to speak on the Migration Amendment charging for a Migration Outcome Bill 2015. Just before I move into the legislation proper, I just wanted to give a bit of a context to our immigration scheme, or the arrangements by which we people who come to Australia are dealt with. First off, you can break it into two sort of groups. The vast majority of people who arrive in Australia are people with a visa, and I'll come to that's the majority of this presentation. The other group are obviously people who come to Australia seeking asylum. If they come in irregular maritime arrivals, they're treated slightly differently to people maybe that arrive by ships, passenger vehicles or planes with a visa and then seek asylum. We do have international commitments, treaties that say we will consider asylum seekers' claims if they're fleeing persecution. Strangely, if they're starving to death, that would not give them grounds to seek asylum. That's one of the cruel realities of the globe, especially when you've got nearly 60 million people displaced throughout the world, some internally in countries and others that have moved from one country to another. But that's the reality. Now, this legislation deals with visa holders, people who arrive in Australia. Now, many people come to Australia holding a tourist visa or a study visa or some work rights, a working visa. Could be as simple as the 417 visa, the food picking and packing. I know I've got a lot of the significant Taiwanese community in Moreton, and many people from Taiwan come and spend time fruit picking and packing and enjoying Australia like a working holiday. There is also another type of visa, the 457, which is a skills, basically designed so the economy gets the benefit of, if we've got a skills gap, bring in people from overseas on these temporary visas. Now, unlike the tourist visa or the study visa or the working holiday visa, 457s can actually, from all but the moment they start here, start the journey to applying for citizenship, unlike those other visas. This is my understanding of it. Now, if you come here on a tourist visa and you meet an Australian and fall in love and then want to become an Australian, you would not be able, under your tourist visa or your working holiday visa, to stay in Australia. If you wanted to change your visa status, you would have to leave the country. It might only be temporary, just go to New Zealand for one night and come back and apply for a different set of arrangements if you've fallen in love, or if you're a tourist and want to change to a study visa, you like our universities. So most visas, you come to Australia under that visa scheme, and then you basically have to leave and then reapply. I think there might be a slight change if you're seeking asylum, but the vast majority of the people we're talking about are 457. People come here. For example, when the mining boom was at its peak, there was a real shortage of mining engineers. So we had an intake of mining engineers, particularly from South Africa and a few other countries. Now, with the mining boom well and truly off the boil, there's not the focus of any good government is on giving jobs to Australian mining engineers, so that we wouldn't be taking that skill shortage. Well, there wouldn't be a skill gap. We'd now have enough mining engineers. So that's just a short explanation, basically, of these types of visas. There's 457s in particular, which are a particular what this legislation is. There's some mischief created from it. So the amendments that the government has put forward are sensible amendments, and Labor will be suggesting some others in the Senate. Basically, the legislation before the House says that it be made unlawful for a sponsor to be paid by visa applicants for a migration outcome, and that this be reinforced by a robust penalty and conviction framework. So it's this situation if you had someone from China saying, someone with connections to China saying, right, to the person, I will sponsor you, give you the job, you know, if we've got the skills gap, I'll give you the job, and that you would actually pay me. You would pay me, and it would, in certain circumstances, people would be so keen to come to Australia because of our higher standard of living and our great system of support, that they would say, all right, well, I'm happy to basically, you know, get my wage in one hand and then, you know, give a backhander back to the employer or the sponsor, so that they're able to stay in the country, as I said, because the clock would be ticking, so that they could then apply for citizenship down the track. It's not what the 457 skills gap visa was intended to do at all. It was a visa that was designed to support an economy that was booming. It's not designed for people to exploit vulnerable people in other parts of the world. So, and as we saw recently with the Four Corners program looking at 7-Eleven, there was people on study visas can be exploited. It's easy for people to import their understanding of workplace relations from their country and what might be a reasonable wage over there and say, oh, well, I'm prepared to get that here in Australia. Obviously, that undermines the conditions of other workers. And I know it's a problem. In fact, I've been talking to Ken Lay from the Taipei Economic and Cultural Office from about catching up with some of the Taiwanese backpackers or people that come on the working holidays and see how many of them, that some of them have been exploited, sadly sometimes by the people from the Taiwanese community who are the unscrupulous people between the farmer or the producer and in hiring these Taiwanese backpackers, and they sort of get, you know, paying ridiculous amounts for accommodation, paying, you know, for transport to pick tomatoes and all sorts of things. So at the moment, the government has no specific powers to take legal action against such payment for visas activities. So this bill will make such activity unlawful in relation to certain skilled work visa programs that have either a sponsorship or a nomination element. Now, we know it can be exploitative. I've heard stories, I've had people come to my office to talk about their tales where if they speak up, they run the risk of their sponsor sending them out of the country. I think previously, if you had your sponsor, your employer, normally, severed that relationship, you could be, I think it was 28 days you were sent out of the country. So between you speak up about some treatment at work, and we sadly saw sexual harassment, employers or sponsors requesting sexual favours so that they did not deport someone, particularly if they were near the end of their time in Australia, where they were close to meeting the time frame so that they could become apply for Australian citizenship. Such exploitation does occur, and if people are, lied to about their right to join a union, it can be problematic. So this legislation is designed to reduce the chances of exploitation, and protect vulnerable workers. And there is a Senate inquiry currently into that. Based on the submissions to the inquiry that we've seen, the Labor Party is going to make a couple of amendments, suggest a couple of amendments to the government. Firstly, we are seeking to apply this bill not just to 457 visas, but also to persons on student visas and persons on working holiday visas. As I said, that's something I'll be taking up with the Taiwanese representative in Queensland, Ken Lai. In fact, we're going on a bit of a road trip to sort of talk to some of the Taiwanese community who are being exploited, is my understanding, are being exploited. The second amendment is to make clear that basically for the penalty regime that's outlined in this bill, which could in some circumstances apply to to the visa applicant, the employee, who's often the vulnerable person, that would not be able to occur in circumstances where it is clear that the visa applicant has been coerced by the sponsor or a related third party into offering, making, asking for or receiving a benefit. Or if the visa applicant has been the subject of human trafficking, which does occur, forced labour or slavery offences under the Criminal Code. In other words, if we want to protect the victims, the people that speak up about the exploitation, we don't want them to be the subject of the penalty. The third set of amendments that the Labor Party will be putting forward is to do with to increase the level of penalties for sponsors in respect for breaches of the Immigration Act. So a further disincentive to them exploiting. The fourth amendment is to institute a new measure which would say that any person in this country who is working under a student visa or a working holiday visa would have to be employed as a person, rather than the requirement nowadays that often occurs where they say you go and have an ABN. So they'd then have all the requirements of that come with being a business, having an Australian business number. So we'd be suggesting that they should be employed under a contract of employment and treated as a real person, because too often people are exploited as a business. They're not paying it does happen more and more where people are trying to get out of their obligations they have to their employees. The Fifth Amendment is about protecting whistleblowers. We saw that in the 7-Eleven case, where those brave people and the investigative reporter and that work with Four Corners to actually tell these stories, and it was just happened to be an observant member of the public, I suppose, or the investigator then went to Four Corners and was able to detail this horrible exploitation where, systematically across this, well, I shouldn't say every one of the 620 stores, but certainly there seemed to be systemic underpayment of the 7-Eleven workers. And thousands of international students who were here to study were being exploited in the course of their work. So, the chairman of 7-Eleven, Russell Withers, did resign, but there is obviously, I don't think that's the end of this exploitation of people on such study visas. So very important that there is a robust system of protection for whistleblowers. The Sixth Amendment we'll be putting forward is the requirement that the Minister table an annual report about the operation and impact of the provisions introduced as part of this legislation. And the seventh one is making sure that unions are part of this solution, where unions or registered employee organisations be able to undertake prosecutions for breaches of the Migration Act. Now, the Labor Party has come a long way in the last 130 years regarding workers from overseas, from having a closed protectionist view to now accepting that overseas workers can play a valuable role. You talk to the organisers at the Meat Workers Union, and they'll show their newsletters in 3 or 4 different languages. Happy to work with overseas workers because obviously if everyone gets paid the right amount, they're not undercutting the conditions for Australians. So that's what the modern union movement is able to, how the modern union movement is able to assist in making sure that the Migration Act does its job, which is all about making sure the people that come to Australia come here for the right reasons. The people that come to Australia work under the appropriate conditions, that if the exploitative, or I'm loath to call them criminals, but the people who exploit this situation, the aspirations of people in other countries, don't receive remuneration, don't make money off the sweat of the brow of people, of these visa holders. So I commend this legislation to the House, particularly the penalty and conviction the robust penalty arrangements, and it would be nice to see a few convictions occur so that the message is sent: do not exploit these overseas visa holders.